YouTube, this is VidHead85. Thank you so much for joining me for this video. I am going to be talking about a court case involving Arkansas and similar laws having been struck down in Tennessee and Florida, I believe, has had similar action as well. So if you must be under a rock if you have not heard of the gender affirming care bans that have been put into place, period, for anything. So last month, in June 2023, the Arkansas gender affirming care ban was struck down by a federal court. Now, honestly, I believe this law should be subject to strict scrutiny. So there are 3 levels of scrutiny for a law to be declared unconstitutional. Rational basis is like the entry level. Some phantom thing, the legislature could have some kind of rational basis for this. I've literally seen that in New York Hernandez versus Robles in the majority decision. The legislature can just imagine something, and that's why they don't want it. So, and then there's intermediate scrutiny, which is a little tougher, and then strict scrutiny is 3-pronged, and it's like, is it a governmental thing? Is it de minimis or the least restrictive, and does it have a compelling government interest? So, because of it discriminates against on the basis of gender identity and expression as well as sex, a suspect class is someone pretty much a minority. It discriminates against a suspect class on the basis of sex because it prohibits transitioning from one gender to another. So the case is called Brandt versus Rutledge, which challenged Arkansas Law Act 626. According to the ACLU's website, 4 families of transgender youth and 2 doctors have challenged the law that would prohibit healthcare professionals from providing or even referring transgender young people for medically necessary health care. The law would also bar any state funds or insurance coverage for gender-affirming health care for transgender people under 18, and it would allow private insurers to refuse to cover gender-affirming care for people of any age. Holy shit. We all knew that they were going to sneak a ban on transgender anything, even over 18. So I'm disappointed, but I'm not really surprised. The lawsuit filed in federal court alleges that House Bill 1570 is a violation of the U.S. Constitution. So here are some snippets from the case, and this is the first one. For example, Arkansas submitted to the district court a report from the Councils of Choices in Healthcare in Finland, in which the council concluded that, in light of available evidence, gender reassignment for minors is an experimental practice. But the report still recommends the gender-affirming care be available to minors under appropriate circumstances. SRS is usually not given to minors, but they usually are able to have puberty blockers. Puberty is a horrible time for cisgender people. I can't imagine the utter hell it could be for a transgender teen. I remember an episode of The Amazing Race Canada Season 2, there was a task called Motion, in which the contestants had to dress up for an indigenous dance, where they had to show a lot of skin. Hamilton pretty much said, we're going to use our express pass on this one. Body dysmorphia is a devil of a thing, and one doesn't have to be transgender to experience it, of course. But can you imagine going through puberty in a body that you just wish you didn't have? Even though the Finnish council said that SRS for minors is not recommended, they still suggested gender-affirming care outside of that be administered. This cuts against the case as it is a solution of the law, as it is a solution in search of a problem, like most GOP laws. The next snippet is this. Act 26 prohibits gender transition procedures, which are defined as procedures or medications that are intended to change the individual's biological sex. The statute defines biological sex as the sex at birth without regard to individuals' psychological, chosen, or subjective experience of gender. Oh God, they're evil. We know this, we know they're evil. Let's move on. A minor born as a male may be prescribed testosterone or have breast tissue surgically removed, for example, but a minor born as a female is not permitted to seek the same medical treatment. Plaintiffs allege that Act 626 violates the Equal Protection Clause of the 14th Amendment because it discriminates against minor plaintiffs and physician plaintiffs' minor patients on the basis of sex and transgender status. So as I said, it's pretty much just sex is between the legs, gender is between the ears, but a surgery routine for a minor born male would be impossible under this law because a minor born female would not be able to get the surgery under any circumstances. So to the history, on April 6th, 2021, the Arkansas State Legislature overrode the governor's veto and enacted Act 626. But Arkansas does not contest that the plaintiffs have met the burden under Lujan to challenge other parts of the act, and that this court declines the state's invitation to modify well-established constitutional standing principles to require that a plaintiff demonstrate an injury traceable to every possible application of the challenge statute in order to satisfy the constitutional standing requirement. So pretty much they're trying to say that to lift the bar on standing, even though they do have standing here. And then I'll get into that because standing is definitely important when you're bringing a federal case. According to the rules of federal rules of civil procedure. Okay. I just read up a lot of law. I'm not a lawyer, but I just know a little bit. The district court found that the act prohibits medical treatment that conforms with the recognized standard of care for adolescent gender dysphoria, that such treatment is supported by medical evidence that has been subject to rigorous study. The act is not a ban on treatment, but to ban an outcome that the state deems undesirable. So standing pretty much says I have a dog in this fight. I am harmed by the law, not just something out of the sky that could happen, but this is real consequences for me. I like that the judge says what the state deems undesirable, because in other words, the legislature is using its power to ban what it doesn't like. Now, of course, there are certain things that are acceptable and others are not if this is the effect. States can do that, however, but again, they have to abide within the confines of the Constitution of the United States, and even if they're under state law, their state constitutions as well. Additionally, there is substantial evidence to support the district court's conclusion that the act prohibits medical treatment that conforms with the recognized standard of care. Additionally, it is always in the public interest to prevent the violation of a party's constitutional rights. These interests weighed against the potential harm to Arkansas of not enforcing Act 26 between now and a final ruling on the merits of this litigation convince us that the district court did not abuse its discretion in granting plaintiffs' motion for preliminary injunction. Because we conclude the district court did not abuse its discretion in granting a preliminary injunction based on the plaintiff's equal protection claim, we need not address the state's challenge to plaintiffs' other claims. The decision of the district court is affirmed. So after this, it could be appealed to the 8th Circuit. I know that 14 of the judges in that circuit are conservative, so it's probably likely on par with the 5th. Talk to you later. Have a great day. I stand with my trans siblings, brothers and sisters, non-binaries, all of you. We're one. They attack one, they attack us all.